Generally, a trespass to land is the intentional, unauthorized, and unlawful entry onto the land rightfully owned or possessed by another, resulting in an injury or damage. However, a trespass to land may be privileged in an emergency situation when it's necessary, or reasonably appears to be necessary to prevent serious harm. In Rossi v. DelDuca, the Massachusetts Supreme Judicial Court considered whether this necessity defense applied in a case involving a dog chase. Patricia Rossi was an 8-year-old girl who lived with her parents in Methuen, Massachusetts. In September 1955, Rossi was walking home from school with her friend Cecilia. As the two girls walked by the houses of Arthur and Samuel DelDuca, two brothers who lived next to one another, they saw a German Weimaraner dog coming toward them. The two girls got scared and ran down the street. In an attempt to escape, the girls cut across a field owned by Ernest DelDuca, Arthur and Samuel's father. Tragically, however, while on DelDuca's property, Rossi was attacked and injured by his two Great Dane dogs. Subsequently, Rossi, by her next friend, sued DelDuca in state superior court to recover for her injuries under a Massachusetts statute. Specifically, the statute provided that dog owners were strictly liable for injuries inflicted by their dogs, unless the victim was a trespasser or committing another tort at the time of the dog's attack. The case proceeded to trial, and following Rossi's case in chief, DelDuca moved for a directed verdict, arguing that Rossi was barred from recovery because she was committing a trespass at the time his dogs attacked her. The court denied the motion, and the jury returned a verdict for Rossi. The court then entered judgment on the verdict. DelDuca appealed, or took exception to the court's denial of his motion for a directed verdict to the Massachusetts Supreme Judicial Court.